The challenge is not for me to have to hold it,
Yeah.
but as people get quieter, it may get easier. We doing okay in the back? You can hear okay? Yes, thumbs up, good. The final panel takes us down to the nitty-gritty, where the rubber hits the road. And this is the road of intellectual property. We have a great group of lawyers on the panel. For those who don't know them, I'm going to give quick introductions, and then we'll get into the thick of it. So Keith Berets works with Cooley, where his practice is with technology companies, and he's had to deal with these issues for some time. Sitting next to him, Gene, who is with Kilpatrick, Townsend, and Stockton, which is a national law firm which has a strong IP group. He also is active in counseling companies. Robin Evans is our regional director in the U.S. Patent and Trademark Office here in Colorado. We're thrilled to have her join us. We also have Jason Haislmaier, who is a long-standing presence here at Silicon Flatirons, has dealt with these issues for quite some time. And finally, Christy Searls, who is the second Colorado Law grad of the panel. Jean and Christy both graduated from Colorado Law. So and she's at CenturyLink, where she's the IP guru there. So we have a lot of rich material to work with. I'm going to get right into a case study that follows from Brad's research. And you can think about this as the opportunism threat. If you are a mentor and you're working with a company without any formal relationship, and the company says, we want to actually capture the value that the mentor helped us create and protect it as a trade secret, is that company in a position that they can actually protect it against the mentor, or by definition, because they've had this outside mentor with no formal relationship, no pay, are they actually unable to get intellectual property protection? Put plainly, is this free give before you get mentoring culture that can give rise to lots of innovation somewhat at odds with IP protection? I'm going to let Gene take the first whack at it.
Oh, thanks, Professor.
Exactly.
How long do I have for this exam question?
This is an exam. For those who don't appreciate it, this is like a final exam question.
So the way Dean Weiser phrased this, he was talking about trade secret protection, and when he emailed these questions in advance, so hopefully we have a little bit of time to prepare. But
Get them?
you did?
Me either.
Sorry, Keith. So
Howard alums get treated a little special.
So the first thing that jumped to my mind, my training as a patent attorney, was this is a really interesting question because it is sort of related to who is the first person to own an idea as it comes into conception. And in patent law, there's a fairly codified framework for trying to figure that out. It's certainly, when you apply it, it's imperfect, but at least in theory, whoever makes an inventive contribution is the first owner of the idea, and then they can go ahead and they can try to further write that down into a patent application. And then once the patent application is filed, they are the first owner. Now, oftentimes they're obligated to assign that right to somebody else, particularly an employer, and there's lots of rules and lots of cases about this. And there are actually lots of rules and lots of cases about inventorship disputes over patents. What was interesting about this question is we're talking about trade secrets. So who's the first owner of a trade secret, especially because the idea of inventive contribution certainly isn't codified, and I don't even know where it would be at all. So I went and did a little research on the internet, and the internet didn't really help me very much on this either, interestingly, in large part because oftentimes what you see lawyers talking about with respect to trade secrets on the internet is where there was already an agreement in place beforehand about who is going to own the trade secret. So the presumption was, it was a contractor or an employee working for an employer. There was already an agreement in place about who would own that trade secret, regardless of who first conceived it. So where it ultimately ends up here with me is, I would say, joint ownership between the mentor and the person who is trying to get that idea basically proprietized as a trade secret for himself. Now, if you have joint ownership, that means each person is free to do with the idea what they want, which can make it very complicated for the person who wants to own it all by himself. Another thing that comes into play with trade secrecy, and then I'm going to stop talking because I've got other people here who are more expert than I am in a lot of this, is basically, is this really a secret, or is it open enough, especially if you've got two different people who are collaborating on it together, one of whom may be telling their friends, the mentor, that it would even be able to qualify as a trade secret under our laws about trade secrecy.
So Robin, you've been actively engaged, as Gina's answering. Clearly this has hit a chord with you. How do you analyze it?
I think Jean hit it right on the money. It's all about ownership, and trade secret is about ownership, and the one way or a way to lose a trade secret is either owner disclosure or owner authorized disclosure. So if you don't have an agreement up front and you've disclosed it to a mentor without an agreement, as Jean said, either or both can do what they want. So I have no idea how this would remain a secret when you have more than one owner without a formal.
Now I'm going to quickly go to your core expertise here because it's an obvious one. When you can't get a trade secret or can't keep trade secret, an option is a patent.
Yes.
So the other thing to ask you both, if you seek to file a patent where you have this other inventor, you mentioned that if you're the first to file, you might be able to get it, but would you be able to exercise the patent against the other person who kind of co-invented it with you, or that person have some kind of simultaneous invention immunity from the patent?
I don't know about immunity, but I think that if there is no formal agreement in place, the first inventor to file would have ownership of that patent. Now, could someone else do it? Certainly. Is it a derivative? Did I disclose it to you? Then whatever I disclose to you, you cannot then own, right? So and Gina's nodding. And so when you file the patent application, you're filing as the first inventor.
So just to play this out, in the other version of this, the mentor says, this business has a fundamental strategy based on something that I can patent. And the mentor goes ahead and patents it without telling the business. Can they get away with that?
Well, again, if they're collaborating together without an agreement, ownership really comes down to it. The first sort of cut is who made an inventive contribution to whatever was claimed in the patent. So if both parties say, I read your claim, Professor, and I noticed that I made an inventive contribution to that, yet you didn't list me as an inventor on the patent, that person potentially, the mentee, could go and make an argument they should have been made a named inventor on the patent. And once they are, if they can succeed at that, then they have as much rights in the patent as the professor, which gets very complicated. And that's a lot of the reasons why people generally like to have agreements in place before any of this goes on. Now, one other question, I don't want to get too much on a tangent, is in this hypothetical, I think we were talking about business methods. So the question becomes, will this ever actually become a patent under our current patent eligibility rules that Director Evans knows very well is another issue. But.
And we'll be having a conference next fall on the topic because it is a very interesting point, and it could make this easier, which is if you don't have patents on business methods and maybe even software, you decrease the room for these hypotheticals to actually happen. But for now, let's leave that as an open question. So Keith, you actually are in the world of working with companies for whom this is not a hypothetical final exam, but they live it. How nervous does it make you as a lawyer of these companies that their core strategies, whether would-be trade secrets or would-be potentially intellectual property and patents, is so loosey-goosey?
So probably 7 or 8 years ago at the start of this process, I would have been a lot more nervous. I would go back, I would actually question the entire premise that there's not a contract. There's not a written contract. I think most of the people in this room probably know that venture capitalists don't sign non-disclosure agreements, right? So that is a common practice. When you look at the definition of a trade secret, one of the factors is whether you've taken reasonable steps to protect it, right? So if you're talking to a venture capitalist, you've disclosed a trade secret without a non-disclosure agreement, that would not necessarily constitute unreasonableness, right? I think we've gotten to the point in the accelerator environment that a disclosure to a mentor is in the same context. And if you look at, again, what's reasonable and what's not, you could make a fairly good argument that that was reasonable under those circumstances. To go to the contract point, as we heard some of these other panelists as well, would it rise to a contract? There are, there are these credos and the points of what these mentors are, their expectations are when they come in. So that could constitute as well, arguably, a contract, and you could make a claim around that. Is that what I would like my clients to rely on? Not necessarily, but it is the reality. I am not going to tell them, to stay away from these environments based on that. I do think there's something we should talk about later, maybe the steps, because, and this goes to a lot of what Brad is talking about, I think we're at the early stages of this, and it makes a lot of sense at those early stages. When you're looking at investments, sort of that next stage, and the venture capitalists who want to see the paperwork, that's a little different. When you're looking at buyers who want to do the diligence, then it's another question. So, but stop there.
So Jason, you've been around accelerators for a while now and have watched this. Keith posed a provocative question. Would a mentor manifesto that said things like, you don't patent intellectual property of the company in a way that is aiming to be potentially at odds with that company, you don't disrespect trade secrets even though you're under no obligation, would that mentor manifesto constitute some basis for a protected relationship? And should accelerators have mentor manifestos that spell that out in writing?
So, first question first, I think you certainly would want to look at that if you were going to have to argue that if you were looking at Keith's theory and saying, hey, we need to find a contract. What are we going to look for? I think looking at a written manifesto that everybody has bought into, all participants have bought into, the rules of the road. And if those rules of the road do actually get specific enough to talk about what claims are going to be made, and I don't mean patent claims, but claims of ownership that are made to intellectual property developed in the mentor-mentee relationship, I'd absolutely want to look at that. And I think the more specific it is, the more you could conceive, given the right facts, that it could actually be relevant evidence to proving a contract. You could also look at it as being, and with the right facts, relative evidence to steer you outside of that too, because the more specific you get, the more you leave outside of the situation too. And so I think it's a double-edged sword. I think there's another kind of issue here or umbrella here over this, and that's when you talk about a manifesto, written manifesto, even an unwritten manifesto, before Techstars had a manifesto, it had a manifesto, right? It had a social set of norms. And if there's one thing that's clear from the time I've spent with accelerators and incubators is that the mentorship and the mentorship consistent with a set of norms is really the secret sauce. It's more than the secret sauce, it's the foundation, it's the bedrock. And what is really interesting is those social norms have what I have seen to be NDA-like force in that community, where it's not the lawyer who gets the call, hey, give this mentor a call and bring them back into line or let them know the law. It's the VC who's also a mentor who gives them a call and says, look, you're going to pretty much get kicked off the island if you play this way, right? And it's amazing how quickly folks snap back into line. There is an incredible social force that is brought about by the terms, the social norms that are manifested in a manifesto when it's written down.
So that works as long as you have repeat players I'm going to get to the standard setting context in a minute, which is a fascinating case study, which has some similarities. When you have repeat players, you have good incentives for, let's call it productive collaborative behavior. If you have one-shot players, incentives can get a little bit more mischievous. That scenario, I suspect, Christy, worries established companies a little bit more because this phenomenon we're talking about has gotten interesting to companies. In fact, Techstars has created a huge model around co-branding accelerators adjacent to companies, exposing companies to this ecosystem and to this informality, which could bring innovation, but brings these kinds of risks. So from the more established company perspective, how do you take a look at these issues?
Yeah, well, I mean, it's sort of interesting. I mean, I look at this particular problem and think that in general, when you see what remedy the law provides, it's usually a just remedy, right? So I tend to agree that somehow, whether it's equitable or an implied contract or whatever, right, you know, that the right result would come out of this. But uncertainty in the large corporate context is very challenging. And I would say that, you know, as a lawyer looking at this, and this sort of goes to the sense I was getting from the audience about their view of lawyers early on, that really our job is to not say, you know, to the business, look, you can't do this without this kind of documentation in place, but just to say, look, there is a risk here, right? This is a new world. It has new rules, and there are certain risks, IP ownership, you know, being one primary one. But I think in the end, what's going to happen is what's the benefit that the company's going to get from the innovation, right? Speed to market. I mean, we see this, and I know we'll talk about open source too, right? This has just been a trade-off. If you look at a company like CenturyLink that comes from sort of the Bell Labs, I mean, this sort of quintessential, right, like patent factory. But you know, you gotta get to market quickly, and so you've just got to open yourself up, I think, to you know, maybe a little bit more uncertainty around IP because there are other business objectives that are maybe more important.
So one area of great uncertainty right now involves the word, you hear it a lot in certain circles, standard essential patents, and let me unpack that for people. When you have a standard setting body, and Cable Labs, and we heard a little earlier today about DOCSIS, is an example of one. Another would be the 4G standards that developed for wireless broadband, LTE. You have these bodies that bring together engineers from all these companies collaboratively developing a technology. The big question is, wait a minute, what's going on with the IP there? And sometimes those standard setting bodies have policies that might be as strict as, oh, wait a minute, if you are a part of this ecosystem, you have to license any patents that you have that are essential to the standard, thus the phrase standard essential patents, royalty-free. That would be, some would say, an extreme regime that the World Wide Web Consortium, for example, had adopted. Another one would be, no, you have to license them at reasonable and non-discriminatory terms and conditions, which, if you're looking for an uncertain term, welcome to the legal world.
It's a nice acronym, though.
RAND, exactly. And then they got
FRAND.
exactly interested in calling it fair, reasonable, non-discriminatory terms. They get FRAND. So RAND or FRAND standards was seen as a safeguard against, and you've already heard me use this word, opportunistic behavior. The opportunist behavior is the one-shot deal where someone comes in and says, oh, I have a patent on something that is essential to the standard, and if you build a whole system, whether it's a cable modem system or a LTE-based wireless broadband system, and someone has a single patent, and they say, oh, you need to buy a license from me, and the consequence of not is I'm going to get an injunction on your use of this whole system, that becomes a valuable patent, even if it was not so valuable, call it day one when the standard was first made, when they could have easily used a different technology. So my question to you all is, how does this standard setting body IP policy framework work in practice? And is RAND a mechanism that is, using Christie's generous view, the law getting it right and we get to equitable results? Or is this a huge, morass of uncertainty and litigation that is out of control? So, Gene, you're giving away your answer.
Am I?
I'm reading your answer as yes. It's a
I'm just getting excited about all the billable hours. Anyway, so
it'll compensate for the non-allowable of business method patents.
there
So
you go. So anyway, FRAND licensing is complicated, and these standard-setting organizations actually are often conflicted, in my experience, because you have really two groups in these organizations. You have the makers, the producers, who are very much interested in getting these standards set, and then everybody can market their products, and their goal is to have to get a biggest market as possible, so and everybody buying products on the same standard. And then you have licensors. You have companies that are really just more there because of their IP, and their business model is to make money off royalties, off the IP royalties. So you can already imagine that these two groups might not see eye to eye on things like what's a reasonable royalty and how many patents should I put into my standard essential patent basket as part of this. And because of those tensions, the really big standard-setting organizations, things like IEEE, have a hard time taking a position at all about what is a reasonable royalty. So they'll announce very vaguely, the way Dean Weiser said, oh, whatever's fair and reasonable, but they won't put a number on that. They won't say, okay, that's 5% or 3% or 1%. And that's in large part because some very big players in those organizations don't want any numbers on those things. They want them left as open as possible. So if the standard-setting organizations aren't really giving a lot of guidance, is anybody giving guidance? And I would say the answer is the courts right now are probably by far giving the most guidance on this, especially the Federal Circuit. So the Federal Circuit is actually taking cases where they're labeling patents that are considered standard essential patents. There are a couple of pretty interesting cases coming out recently about, okay, if it's a standard essential patent, that means there's no injunctive relief, which can be part of patents. There's only monetary relief. And we're going to go in and we're going to do some very elaborate analysis of what we think is fair and reasonable. We're going to put numbers on it. And so I think that right now, the courts, more than the standard-setting organizations, are driving the reality, the brass tacks of what FRAND means.
And Rob, this has been something that's been looked at I'll get to you in a minute, Jason, at the PTO a bit, and you guys put out a statement with the antitrust division that I think guided one of the things Gene said, which is a fairly limited category of cases where an injunction would be appropriate involving a standard essential patent. Would you want to add anything to what Gene said?
Well, I think that, like Gene said, you have to know who is in this group and who is in this contributors group, and also realize that it's a certain number of patents, and it's a kind of a limited number of patents, and there's still a lot of innovation that goes on around it. And even with chem labs, they're talking about the signal that comes in and the signal that goes out. There's still a lot of innovation within that black box, right? And so even with FRAND, there's still a lot of patent protection that's going on, and the courts are deciding it.
Jason, you want to jump in on that?
I was just going to add, I didn't disagree with what Gene said. I think it maybe as an and, not a but, is the part of why a patent, why you can look at the Federal Circuit saying, hey, we're not going to allow injunctions in patents that are standard, or with patents that are standard essential patents, is because almost invariably that is a standard setting organization that has its act together, right? Whose policies are well drafted and well thought through. Now, more and more we see that. There's been a tortured path to get there. But I think that's what's giving the courts the basis to say that. And so from a company standpoint, you say, well, what's the takeaway? Well, all standards organizations aren't created equal, certainly not technologically, but also from the standpoint of the rules they put in place. And I think my experience is these rules, whether it's startups or even established companies, these rules are often not looked at very closely simply because we're interested in the standard. We have to get involved because we've got a team that really is interested in it. I think that one of the takeaways here that's valuable is, yeah, do look at those rules, because while they are getting better, while the watermark's getting better for the policies that govern these standards bodies, there are some that are still very different from others when it comes down to it.
Well,
Christy?
and I would say, look at who's influencing those
Yeah.
rules, right? Because the way this happens, oftentimes there will be an ad hoc IPR committee where lawyers from the various members get together and, you know, sort of try to negotiate. And you know, if you see who's leading the charge, it will probably give you a lot of information about, you know, how it might come out in the end, right?
So Christy, one question for you and for Keith as well, which is, when you're advising the engineers in your company about going to these standard setting bodies, how much can you be controlling and be out front of it? Because one of the risks is that companies have people going to standard setting bodies that the company doesn't even realize, and by participating, they're implicitly making limits on that company's IP that you may not even know about.
Well, right. I mean, so within our company, we've got, of course, because we're a big company, right, we've got a lot of structure around that. We've got a guy whose job is to, you know, oversee all of that. And we're maybe a little bit more coordinated, but, you know, than some smaller companies. But you still don't necessarily have a lot of control, which is where I think the philosophy is, you've just got to be bought into the policy and whatever, you know. I mean, there's a business imperative for being involved and having input into the standard that sort of trumps whatever's going to happen with your patents on the back end. And you kind of have to come to that realization. I mean, different companies, again, this goes to who's putting the policy together, because that's my company's perspective, right?
Look at W3C, right? They weren't always royalty-free.
No.
Originally, they were going to allow web standards that were not royalty-free. That got a lot of pushback.
Yes.
Not just from all the entrepreneurs out there and smaller folks, but by some bigger folks too. And so this influence question, there's an example right there where that swayed it the other way.
So Keith, what Christy said, this is a powerful lesson for the law students in the room, is a certain flexibility is required in terms of counseling companies and working with companies as they participate in these standard setting bodies. How do you approach this issue?
I think certain is an understatement. Usually by the time I get the call, it's pretty late. So in fact, I can give you sort of a minor example that happened just 2 days ago, where a company was about to release a press statement at a major marketing event based on their use of a testing tool put out by a standards body. Of course, they downloaded the light testing tool, right, off of the internet and agreed to an agreement that they didn't realize said they couldn't use the results of that test, right? So no real IP there. It probably wouldn't have been a copyright violation, but it was a confidentiality type, right? So then if they want to do it, they've got to either negotiate a full license, a commercial license, or become a member, which is a $30,000 a year fee. So that's the kind of conversation that I have, right, around what do we do now and how do we fix this. I do think, particularly in the early stage startup environment, right now, I think the landscape is going to change, both with standards bodies and with regulatory bodies, and it's similar, because startup companies they're really not created to deal with that. The costs from a legal standpoint and an implementation standpoint are really high, but yet they're just going forward. And so to the point of you can't get an injunction, at some point you can't stop that process as well. And so there's going to be a need to address it, ask for forgiveness instead of permission.
So in terms of messiness in this world, I do think the prize goes to open source development, where this whole regime was built often on ideological premises that there shouldn't be patents that would get in the way. The problem with that premise is it's inaccurate, that there are and can be patents that get incorporated into open source development. And so, Jason, you've thought about this issue for a long time. As you see the current state of play, what do you tell companies, both entrepreneurial companies and more established ones like Christie's, how to engage around open source development when You know, you use an open source product, you could be engaging in patent infringement without knowing it. When you contribute to it, you might be sacrificing your own patent position. What's the advice you give?
Yeah, so it's not copyright, all rights reserved. It's copyleft, all rights reversed, right? From back on day one of open source. And you know, you look at that, and that's even a little bit of misnomer. You know, when you talk about intellectual property, copyright is the bedrock of open source. You don't have the right to open source software unless you own the copyright. That's the essence of it. At the same time, you look at patents and you say there is no other intellectual property that's a greater threat to open source than patents, probably. Now, I think it's also it's correct and it's instructive to look and say you can make that same statement about software in general. And I'm not necessarily saying I'm anti-software patent. It's just as much of a threat to software usage as any other form of intellectual property. Open source software is software. It's the licenses that make it open source. So when you're using licensed software, we all assume, oh, we have software patents here in the United States, certainly of changing scope based on what the courts decide. But we worry about patents when we're licensing software. Why don't we also worry about patents when we're licensing open source software? You know, we should. So step one is you have to look at it as software. The fact that it's licensed under an open source license doesn't make the bits any different, doesn't make the patentability any different. But then, Phil, as you allude to, I think also take into account that the landscape starts to change when you do start talking about the licenses. And in addition to the open or more open copyright licensing aspects of open source licenses, many open source licenses, and not even the ones that are typically the poster children of dangerous open source licenses, the copyleft open source licenses. Many other open source licenses actually have patent license clauses built in. They are reciprocal in nature, and by using that open source code, distributing that open source code, by contributing to that open source code, you may be pledging or agreeing, because we're talking about a license here. This is written. This isn't even an unwritten license. You're talking about giving some type of reciprocal pledge to others who are using that same open source software and distributing it, that you won't assert your relevant patents against them. If you do, now they're all, bear in mind, everybody who's using that same open source software under that same license is making that same commitment, and so it's kind of this mutually assured destruction kind of aspect to it. You go ahead and decide, well, I'm going to break this. I'm going to go ahead and sue someone who's using this open source software with one of my patents. What happens? Well, it's reciprocal, so your protection falls away under the terms of the license. So in theory, you now aren't shielded from anybody else's patents who's using it. So if there are 5 users of an open source project, big deal if there's a reciprocal kind of contractual or license-created patent pool here. If you're talking about Linux, if you're talking about another tool that's widely used by hundreds of thousands or millions of different developers, this can be pretty significant. And so it's interesting. I've been involved with open source licensing since the late 90s, and I can tell you for the large part of that time, the phone rings, the call comes in. It's about exposing my code to an open source license, and my gosh, does my company now have to license that code out under the GPL license? It's not been this patent issue. This patent issue has really been a second wave or a third wave that's come along. And I'll tell you, these patent clauses in the open source licenses are more pervasive than the clauses that can encumber your code by open source terms. So this is a real issue.
So Christy, I have to say, from an opportunistic standpoint, it's both surprising you haven't seen more of the mentor behavior we talked about, although I think Jason's answer explains that. But in this context, you have lots of patents that have been incorporated into open source software. Why haven't we seen more activity on this, and how have companies like yours gotten comfortable saying, okay, we'll just take the risk?
Well, I think that the comfort taking the risk, again, just drives down to a pure business issue where the cost of internal development, right, and not leveraging open source is just too much. It's just too high. I do think that from another strategy standpoint, part of how companies manage patent risk vis-a-vis other companies, is really to have defensive patent portfolios, right? And so I think that that's, even if you're operating in an open source world, for example, our cloud business operates in that world quite a bit, you know, sort of the main defensive strategy is to just make sure you've got, you know, you've sort of got your own patents so that you're in a position where you can cross-license or leverage that.
Now, that's assuming you're in a world of repeat players. If you're against a so-called non-practicing entity whose only game is to sue, that strategy may not work.
It won't work, and actually that problem pervades everything we've been talking about, that you have these rules for people who operate in the ecosystem, right? And as long as everything's within the ecosystem, it all sort of works the way it's supposed to work. But the problem is, exactly as you say, I mean, standard essential patents.
Standard essential patent, for those who, again, are in the weeds of this, you can look up the Rambus case where there was someone who was in the standard setting body reporting back to the company who kept amending their patent application to cover the standard, and that person was called Deep Throat. And then that person dropped out and claimed that the standard setting body's rules didn't apply, and they had the right to get licenses. It turns out the backstory to the backstory is also interesting because the standard setting body may well have been itself a cartel, and this was the maverick trying to disrupt the cartel. So it's sort of a whole intrigue, and if you follow these companies, Rambus and Micron, you can read it. There's probably a great business book to be written on that. Let me get to Gene and ask you the question. How big a risk is the assertion of patents in the open source context out there? Is it a sitting time bomb? Is it being worked through? How do you assess it?
I think it depends on who you're talking about. If you're talking about companies within the ecosystem and operating companies, dealing with other operating companies, I think the risk is relatively low because all of those players understand that cooperation gets you forward. They're repeat players in the business and everything like that. As you alluded to, there's this other group out there called non-practicing entities, pejoratively referred to as patent trolls, who have an entirely different agenda and do not care about who toes they step on, will not snap into line because the VC mentor called them, and are not interested in changing the world for the better. They're interested only in basically enriching themselves and the people who are basically backing their patents, who have invested in getting those patents. So I know that what they will do is they will go after big players and small players. Small players, they'll typically try to just get a quick settlement fee from, and then that funds a war chest so that they can actually mount something bigger on after going after some of the bigger players. And really, right now, the only way they've been slowed down, because there's quite a few players now in this business, is through Congress and the courts, scaling back patent rights in general. Now, there's a big debate that's going on that are you throwing the baby out with the bathwater by scaling back these rights, because not only is that affecting the MPs, it's also affecting operating companies and entrepreneurs who are legitimately trying to build business and raise capital around patents. So that's a whole separate debate, but I would say that with respect to the NPEs, it is a big problem right now for not just the open source community, but everybody. I've noticed in the case of, like, for example, iOS, there was a kind of an infamous troll that was going after all the app developers. And then Apple stepped in to sort of basically go after them and try to invalidate their patents and do other things that a big company like Apple can do. It ultimately ended up where I think they collected enough money that once Apple started really getting involved, they kind of backed off and just went away. But they could come back with some more patents later, or they form, they reformulate themselves. They're very tricky to be able to pin down.
So Robin, I know you and your colleagues at the PTO have spent a lot of time thinking about this issue, and the patent reform discussion in Congress is one you guys are engaged in. What can you add to this point?
I think open source, you have to know what you're getting into and what you want to get out of this open source. If your position is to go in, innovate, and build upon it, and you want to take the risk, then that's your choice. But I think you need to understand what you're protecting and what you're giving up, because I think that's really important for folks to know. What are you giving up? What are you letting go in order to get something back? And what is your gain going to be? And is it worth it? And is it worth it?
So Keith, your reality check is it's not always easy to have that conversation because by the time you get in, they've already made the trade, not even knowing it.
It's also a bit of an anathema to the entire tech system that, particularly that accelerators are usually dealing with. And I know, Brad Feld has written a lot about this, whether they're, the IP protection that particularly comes through patents is meaningful, right? So, and you look at what's happening today, again, it tends to be more about execution, at least in the vision of the small startup company, than it is about, patent protection. So I think the reality check usually is, and again, to Christy's point, the idea is not for us to say no, it's just go in with your eyes wide open. The entire landscape is changing, whether it's through regulatory reform, whether it's through, in terms of the American Invents Act, there are other ways to go after patents, whether it's the office, if you look at the statistics on how many of these patents in particular areas like software are surviving, right? Most of them are not right now. And then you look at what industry is doing as well, which is they're gathering some of these before they get into the hands of the trolls through consortiums, which has sort of this cartel and standards setting, idea to it as well. And you look at things like where Yahoo sued Facebook, right? And that's another example where the entire industry kind of came around and said, not really a good idea.
So one of the uncomfortable developments on this is if you get the repeat playing companies who can't resist the temptation to license or sell their patents to the one-shot practicing entities. And the lack of transparency and awareness around that, it's kind of like dark money and campaign finance. Not really sure, you don't know what you don't know. Where's it all coming from? This is an ongoing saga. Before I get to what would be my final question, though, I want to get to some discussion from the audience. And for those who follow Paul Ohm on Twitter, you'll enjoy that today he mentioned invoking the Weiser rule at a conference in DC. So I appreciate Paul's giving that shout out to our tradition of having students get the first question. As professor, I'm not afraid to call on people. So before I ask Heiner for his question, I'm happy to have other people volunteer. All right, like I said, Heiner, what's your question?
Thank you, Dean Weiser. I guess my question would be to Christy, who I had the pleasure of working with 2 summers ago.
2 summers ago.
2 summers ago.
Yeah.
So how does a company like CenturyLink handle patent trolls? So you get a suit. Do you choose to really litigate them back to hell just to chill future suits, or is it you just pay them off?
How many patent litigation matters do you have going on at any given year, would you say?
So I would say on average for us, and it's actually gone down, which is I think consistent with the industry reports. But on average, we probably have like 12 to 15 assertions. Not all of that's litigation, right? Yeah. But it is trending down.
How do you decide which ones to litigate to hell, which ones to settle? What's your process look like?
Very nuanced. So yeah, I think part of that. It's funny. I sat on a panel where we discussed this very issue with like the guy from GM and the guy from Microsoft and me, and they're like, we fight till the bitter end, and I'm like, well, that must be nice, right? If I had a $100 million legal budget, I would do that too, but but I don't, and so I do think that's kind of a nuanced question, right? Some of it is, who's the assertion coming from? Is it a repeat player? There are lots of repeat players, and in that instance, even on some, you probably spend a lot more. You'll be happy to hear on lawyers than you would be willing to pay to to a troll, but then there are, some of these things that come up. You have a guy, actually we've had a couple of these guys who invented MPLS in their garage on their off time, right? And so they were, they're an inventor. They really believe they have an idea, and it's kind of a one-off thing. And depending, those guys have a good story to tell usually. So I think you have to look at the total circumstances. I mean, but I have budget constraints, right? What's the threat of repeat risk? What's the strength of your case? I think IPR has been a real boon to the software patents. It's provided a very cost-effective way of, taking care of that problem. But I don't know. Anyway, it's multifaceted, but it's a problem, and it's an annoyance for me and lots of other people.
All right, we've got a number of people in the audience. Let's start moving down the row there.
Would you mind comparing and contrasting your views on open source with respect to software versus open source with respect to hardware, open source with biotech, open source with nanotech, a lot of tech that we didn't talk about yet?
Very good point. Open source software is sort of the origin story, if you will, but the concept has been applied in other contexts. Anyone want to take a whack at how successful that model is and what issues it raises?
I'll kick off by saying I think it's fantastic to see what's happened. You can chart this from sitting right here on a panel facing a room full of people who are also entrepreneurs, by the way, who are viewing open source as being a bad thing 12 years ago, to now having a question like this where it's, well, wait, it's working in software, can we apply it elsewhere too? That's right, that's right. It's not, hey, let's try it. People are doing it because it works, right?
The question that I have is how do you look at patent and copyright issues in those contexts differently than you look at?
Yeah. So let me try to frame it this way. This is a really good question. In software, where the premises and the license terms were, hey, patents are stupid in this area, we don't like them, the goal is to clear away patents. In biotechnology, there's now collaborative development, open source space. But in bio, patents have been so fundamental in a way that in software they haven't been played the same role. Can you get through and see a world where you have a lack of patents or a different type of way to enable collaborative development across lots of individual entities without having patents get in the way?
Right, so let's all remember that, again, the essence of an open source license is it's a copyright license. And back at the time when open source licenses came into being, there really weren't software patents as we think of them right now. There really was just copyright protection for software. And Phil's, you're right to point out, hey, when we're in biotech, even when we're in hardware, we're talking a lot more about other types of IP, patents in particular, playing a far larger role than they even do in software today. And so that's one thing to look at is the open source license the right tool for the job? Certainly a lot of the open source software licenses that we have today won't work with hardware, won't work with biotech because the terms aren't right. They're drafted for a different type, a different topography. But the concept of open source, I think, is instructive to look at. Can those same concepts be applied with another license, with an open hardware license, an open biotech license? We've seen it with open documents, certainly. I think the answer is yes, but you do have this issue, certainly, of patents, because that's one of the topics of the panel, playing a larger role at maybe the effectiveness of it.
It's a good topic for another conversation, and someone who has written this area is Eric von Hippel, who has talked about user-based innovation and collaborative innovation in different contexts. There are lots of communities now that can come together using the internet to develop collaborative innovation, and what model can do that is a really rich question. Let's go to the next question.
Hi, I'm Yuriko Morita with Somei Consulting. I have a question. I'd like to bring the question back to, because this is an innovation and entrepreneurship conference, I'd like to talk about that. So in things like, so we've talked throughout the conference about things like MPEG-LA and the Cable Lab Contributors Agreement, and so Standards Essentials patents. What that has done is to give larger companies that can afford to participate in those ready access to thousands of patents, which has had the resulting consequence that patent royalty rates by those companies that they consider are reasonable have gone down to fractions of cents per patent. And now with the reality that entrepreneurs and startup companies, a large percentage of them fail, and at the end, all that's left are patent portfolios. And on the flip side, NPE regulations and those types of things have really made patent worth much lower than they have been. So now I'd like to ask the question, is there still an incentive for up-and-coming startups and entrepreneurs to pursue patent protection?
It's a really powerful question, and there was a study done recently on unicorns and the extent to which they had any patent protection at all. The answer was overwhelmingly no. Is that the accurate state of affairs, do you guys think? Is it advisable? What do you tell companies, Keith, on this? What do you tell companies, Gene?
So I would divide that into two, because I think, and maybe I read into the question something that wasn't there. I don't know if the question was about innovation itself, whether there's value to that. Because I think there's a separate question between whether there's value to innovation and disruption from a technological standpoint to things that are traditionally protected by intellectual property, and whether there's actual value to the filing of a patent or patent portfolio. And like any good lawyer, the answer really depends. I do think that the landscape is changing enough that the answer is different. And our job, I think, as good IP lawyers is to give our clients a good view of what that landscape is and where to spend their resources. You know, and again, lots of these companies, startups range from truly no money to startups that have plenty of money, and they just have to decide where to spend it. I spend time mostly telling my clients that they need to have a strategy. It's more about having a strategy than it is about necessarily filing patents. And again, it comes to what is their focus, what are the challenges they're likely going to face, what are their investors looking for, what's their exit strategy. You try and sort of frame out that landscape and ask where is the value of the IP in that landscape and what's going to get you the most protection. And it's not just about the money, it's about the resources, because having a significant patent portfolio actually requires a lot of internal resources and a lot of, as Christy can probably tell you, a lot of internal management processes. And some companies are not set up for that, and they're not interested in that. And so, you know, people look at you a little sideways when you've got an IP and a patent practice and you're counseling your clients not to spend their money on it. But that's the right decision most of the time, many of the time.
So, Gene, is it the right decision most of the time for emerging growth companies to say, hey, I can't really think about it? Or is that a short-sighted decision that sometimes come back to haunt them? And how do you know which side it is?
Let me just preface that by saying you understand, Phil, that asking a patent attorney if they need a patent is kind of like asking a barber if you need a haircut. To your point, I think Keith raises some very good points, including the fact that patents, the infrastructure you need to manage a healthy portfolio of patents is enormous, both in time and cost. So you have to take that into consideration. It's really the other thing is, as we are evolving what is patent eligible, you also have to consider what kind of industry you're in to say whether or not patents are worthwhile. So like Keith says, I think it really depends. My own personal view is the more sort of natural barriers to getting into an industry, the better patents can help you at least get started. Because like, for example, in the biotech industry, where you need enormous amounts of capital to get started in that industry, patents are critically important to give you a limited time period for a monopoly so that investors will say, you know what, it's worth making the investment here because I've got at least a couple years of monopoly royalties that I can recoup that enormous investment and all that risk that went in with that investment to be able to do that.
That's great. Robin, one of the initiatives of the PTO is to really develop a innovation and entrepreneurship outreach to help this issue get understood by emerging growth companies who don't have the sophistication of a CenturyLink to figure out a whole patent strategy. What are you at the PTO trying to tell those companies in terms of how they should think about this?
So you're right, we do have many people who go out on outreach, and we want folks to understand what is a patent worth to you, and what do you want to put in, what do you want to get out of it. The whole landscape has changed, and we recognize that. So we have things like Saturday seminars for folks who are just tinkerers in their garage, all the way up to companies. Where in the patent process are you? And then we also recognize that patent trolls are out there, and so we have EPQI, which is Enhanced Patent Quality Initiative, where we are trying to make sure that the patents we issue are really clear now, because we know that indefinite claims or claims that could have been written much clearer are where the patent trolls look, right, to go after. So we have a lot of initiatives going on, and we're trying to issue patents that have clear claims, where the language is clearly defined, so that your patent is really worth as much as you want it to be.
And ideally, patents that have been put into practice, because part of the challenge of inventing MPLS in your garage is, oh, I have this idea of something that one day might become an invention, but if I get sort of a functional claim on it now, I'll just keep that as a option value, and then if it actually becomes something, boom.
Right. And some people just want a patent. They just
That's
want
fair.
a patent,
That is-
right? And that's okay.
They want to put it on their wall.
They want to put it on their
So
wall.
that's the famous joke of the peanut butter and jelly sandwich without the crust, right? It's a patent someone's got on their wall. Probably will never be enforced against anybody, but hey,
They got
it's all good. I want to really thank our panel for a wonderful discussion. Please join me in thanking them. And as I said at the outset, we're now going to have a reception, one value of which is to have the type of informal collaboration, particularly with those professionals reaching out to the students. And they have lots of more good questions they'll like to visit with you. Thank you all so much for a really wonderful set of discussions.